this morning?
Good morning, Timotheus. Again, my friend.
Sticks in.
Just gonna have to reach it somehow.
We'll talk about it for a minute. First gets cranked up.
Yep, if you don't mind.
I didn't mind when I was a kid. I sure don't mind now. Good morning, Mrs.
Michael has got some stuff for you from the lady up.
What time? Thing won't stay still this morning.
Why not?
I appreciate that.
I'm probably going to leave about.
Good morning. How are you? John, God bless you, buddy.
Take us to this wonderful book today?
Absolutely. We're going to get into that few things in there today. Yes, sir? That's where the truth lies.
I got a hug for you, dear. Thank you.
Thank you. Thank you for the prayers.
Yeah, love you.
I'll tell you, I need it today.
I'm going to leave about probably 5.
We all need money, not just you.
For that funeral.
Okay. All right. Love you, buddy. We'll be done. We'll have everything covered. And if you need anything else, I'll be here. God bless you, Russell. How are you? See you, my friend. Hello, Brother Carey.
Morning, Jen. Love you, buddy.
You too.
I need to talk to you about that court deal.
Okay. Yeah, we will. Okay.
I need to talk to Tommy about the little meeting we had down at the local, I don't know, where they was having coffee. The guy that owns the Southern Star newspaper
Yeah.
was down there. He was talking about how they were talking about something. He got the Bible and all said, well, you ought to go up there and see all them cars up there, all them gun-toting sovereigns up there. He said, I went around and took pictures of every license plate there.
Who did that?
The guy that owns the Southern Star.
We'll tell him good. We want to add him to the lawsuit.
Exactly. So, keep an eye out here in town for the bank newspaper when that comes out.
Okay. Well, that's good because we'll add him to the list if you ain't careful.
Private property.
Well, if he was on the street, he wasn't, but he could have. Good morning. Good morning, Bill. Good morning, David.
Hi, this morning.
Doing good, brother.
Heart to heart, huh? Amen.
Absolutely, always. And it's time for us to get going.
We love you.
Yes, it does.
Doesn't it feel good?
Not jealous.
Doesn't it feel good to know how much we love you guys?
Yeah, we love y'all too. Very important number that you all need to write down. Yes, ma'am. Can I? Well, I'm in the way. You can't see through me. Boyd, you give me the go-ahead when you're ready.
We're ready to go.
Okay, well, we're ready too. Good morning. Glad you're all here and all survived a night in Alabama. None of the old rednecks got you, I see. That's a good thing. You know, had some, I don't know if y'all saw that TV thing they had going on. They had these guys that were on this trip, and they traveled all over the United States. And they said the only time they got scared is when they were in Alabama. They said they met some guys down here that worried them. They met some of the bubbas down here probably. And we got a few. But anyway, everybody survived, it seems, and it looked like most of you didn't lay out last night too late and get drunk, I guess. So maybe I won't have to throw anything at you and keep you awake. We got a lot to cover today. We're going to get to the nuts and bolts of the process. We're going to show you step by step how to do the process. Before we get into all that, I would like to open with prayer. Brother Gene Exum is a longtime friend, minister. Okay. Hey guys, y'all keep noise down, please. Okay. I'm going to ask him to open us in prayer. Brother Gene, if you'd come up here, also I'd like for you to mention your website to the folks when you get through, if you will. I'd like for you to open us in prayer this morning. I always say we're going to have prayer. If prayer offends you, you're welcome to step outside. It's not our intent to offend anybody. But we're going to pray. I am a Christian man, not ashamed of that at all. I live by the principles and concepts of the Holy Scripture. And I have a right to pray. You have a right not to if you don't choose to, and that's fine. I mean, I don't have a problem with that. If you don't want to do that, it's entirely up to you. That's why I love America. We can disagree and get along. We don't have to kill each other just because we don't agree. But we're going to pray, and if it offends you to the point that you feel necessary to take action, sue me, but you won't like the results. So, Brother Gene.
Let us pray. Merciful God, our kind and our heavenly Father, as we come before you this morning, we ask, Father, that you will look into our heart and help us, Father, to do those things which are right in thy sight. We would pray, Father, that you would help us in trying to carry out the good that we're intent upon doing in this country. But Father, we ask thee also to defeat us in those things that we would attempt to do that are wrong in thy sight. We would pray, Father, that you would go with us through this day, that you'll be with Brother Tim and Brother Tim as they bring forth this process to us, that help them to teach us and help us, Father, to learn. We would pray, Father, that you would keep your loving hand upon each of us, that you would help us in everything that we do, keep thee in our sights. We would pray, Father, that you would go with us as we depart from this place this evening. Keep us safe in our journeys home, wherever we may be from. We would pray, Father, now that thy kind hand be upon all of us, those round about us. In Christ's name we pray. Amen.
Thank you, Brother Gene.
Also, I asked Brother Tim about our website, where hopefully it's going to be and running no later than the 1st. We've got some cards here if you have anyone that's having any kind of problem with mortgages or want to do.
Good morning, Mr. Housefay.
On the internet, you can contact anyone. A full explanation of the program is there. The cost of everything is up front before you ever open up the program. We want you to know that we've been at this close to 2 years now. Been very, very successful with it. But the program is there for you to look at before you decide what you want to do. Once you start the program, you need to finish the program because we use the state law wherever you're located. When you put your address in, it's automatically going to tune you into the laws of your state, the UCC, and it is basically a UCC process. It's non-judicial, but you make up your mind. We've had thousands and thousands of requests for it. We gave away the old 3-day letter that we started with back the first of last year to everyone when we got involved with trying to help people, and it's come back to bite us. We've not taken a new case in over 5 months, and we're still bogged down because I simply couldn't say no to people when the girls were begging me not to take any more cases. But we've got the cards if you want to. One of them, just see me at any time, and we'll be glad to give you this.
Brother Gene, before you go.
There's some on the table out here too.
Okay. Before you go, how many people have requested the process? Tell these folks.
We had, well, at one time, we had one call that asked if we could take 300,000 cases at one time.
So what I'm trying to explain to you guys, the demand for what we do. Okay, there are literally millions of people that want to get free from the bondage on their land and from the banks. We need to, and I'm trying to imprint that in your mind, how important it is for you to be trained and do this process properly and go through the steps that we're teaching and go through the organization that we're trying to show you how we've set it up for you to do, because it will make things work smoothly. Because I'm telling you, if you start getting backed up, I'm telling you, it doesn't get better. It gets worse. And you will be, like Brother Gene, they've been working full time for 5 months trying to catch up because they just got overwhelmed. And it's going to happen to you too. That's why I have prepared for months now. I've been preparing the system for you before we trained you, so that won't happen. Because believe me, I know exactly how it works. Freedom documents. How many hundreds of thousands of freedom documents have been filed in this country? We don't even know. There's probably millions of them, literally, have been filed across America. We almost shut the recording offices down with them at one time because we wouldn't even take them anymore. They wouldn't even take them. I mean, we had to create our own. So we created our own filing system back 3 years ago, probably, in Texas, with a friend of mine in Texas who was a computer engineer. And I told her, I said, you're going to get covered up. She said, we can handle it. She told me, she said, I got so backed up in just a few weeks that I had to hire 2 full-time people, additional people, just to help me try to keep up. She said, I was going to the mailbox every day and getting a truckload of documents every morning. Every day, 6 days a week. She said I was getting a truckload to have it record. And she said we just got so overwhelmed. And one of the things they had the problem with is that people wouldn't do the documents properly, and then she would have to have people call them and get them corrected and what. That's why she got backed up. That's the reason we're training you step by step in this process, so that when they go to the Republic Records Bureau, they don't have to read them. All they've got to do is get them on record, do their little thing, and send them back. That's your job. That's what you will be paid to do. You will be paid well to do that. But we expect you to deliver. We expect you to be prompt. We expect you to be honorable. And you're not going to get paid until you get through. When you put that in the mail, you'll have a check or you'll have a payment, whatever y'all work that out. And this is the man that's going to do all that. He's the guy that you're going to go to. He is the one that runs the main office that's set up for this process. He will have a website. He's already been briefed on, he and I put this thing together, and Tim Pledger put this together to try to make sure that it all works very smoothly. And on his website, there will be the information. There are two checklists. There's one for the preparer and there's one for the homeowner. We don't want to do the homeowner's job. You don't want to get into that. If you do, I'll promise you, you're going to get backed up in a hurry. Let the homeowner do some of their own legwork. The only things that we require for them to do, there's three things, primary things that the homeowner needs to do. They need to bring you a certified copy of the deed, a certified copy of the land patent, and they need to do the public notice. That's the three things the homeowner's got to do. Of course, they got to fill out and give you the information that you need, which is all on the intake form. If anybody approaches you off the street, and they will, they'll call you at home and say, we want you to do this. You give them this number. They call that number, and they are directed to a website that's going to cut a lot of work out for you. Because it's going to explain step by step how they go through and get the land patent, how they go and get the deed, and they will be given your number. You will be in an area, and those people that call in that general area will be directed to you. And this is what we want you to understand. You're going to get covered up. You're going to be so busy in a couple of months from now, oh my God, I don't know what in the world I'm going to do. And it's coming. I'm telling you, like a landslide. I've done this for several years, and you just can't imagine. I had an attorney, won't call his name, contacted me a few months ago, said, I sure would like to help the people. I said, well, can you handle it? I said, because if I put your name out there, you're going to get buried. Yeah. I mentioned his name twice on some calls. He called me up and said, don't mention my name anymore. He said, in 2 weeks I've had 370 calls. He said, I can't do it. He said, well, I told you to get ready. He said, they heard your call, and they called. 370 of them's already called. He said, I've taken 370 cases. He said, I can't do it. I said, well, that's what I'm telling you. And I'm telling you guys, it's what's going to happen to you too. When this information gets out, it's so powerful that everybody is going to want it. Well, I don't know if you've done the math yet. There's only 50 of you guys right now, and there's probably only going to be a few hundred of you across the nation. We're not going to train everybody. We're going to do a few. I'd like to have several thousand, but I'm not going to be able to do it because I got other duties. I've got 4 classes total that probably is all I'm going to be able to teach. And that's going to be just 200 or 300 people. Now, we're going to have other people out training some people, I'm sure, Tom, and then we'll set that up. Some of y'all, they might be calling on some of you to do it because you're not going to be able to keep up with the demand. There's 375 million people, so 379 million people in this country, and they all want to own their land. You do the math. When this gets out, you're going to get covered up. So I'm trying to organize this thing. Nobody's ever organized like this. Nobody's ever organized a group across this nation of freedom-loving, patriot-type people. Never. And I'm trying to avoid the pitfalls and help you avoid the pitfalls because I've already made all the mistakes. I know what you're going to run into. And so I'm trying to help you avoid that. Yes?
So it would be a good idea just to get a new phone number just for this work. I
think that's a wonderful idea. I would. Yes, Bruce?
I'd like to say too, the website, it is up and running. It is not functional at this point. There is information that you can access on there now, but very soon we'll have it up and running. And you will need to create a password and log in. Then you will be able to see in detail, quite lengthy detail, that you need to read all of it and understand the steps that you're going to have to take in this process. Because there is a lot of work that you're going to have to do yourself. Do not buy the product until you read, and it's about, Michael, what is it, about 35 pages?
Yeah, he's referring to Brother Gene's website.
Yes. Now, Right,
So don't-
mastermortgage.com.
Yep.
Mastermortgagesaver.com.
Yeah, that's a,
But these two are not the same thing.
No, no.
We're here today and that.
That's completely
but
different.
But they can work hand in hand together.
Does Tom have up a website yet?
yes, he does. He's putting the information on it now. He'll have it ready. I told him he needed to be up and running by the first of the week.
Okay, so we just call him and get that website.
Yeah, and he's going to issue your certificates. He will issue you your certificate number. That has to be on file in the Republic Records Bureau, or you will not be able to record your documents. Okay, that's how we're making sure that nobody pirates this process and goes out there. And I want to make it abundantly clear, okay, I am doing this in my private capacity, not as the president. Okay, I've got to make sure, because Congress has already told me they're going to whack me if I don't do that. And Edna. And she will too, I'll guarantee it. And anyway, they've let me know that I have to make sure that this is not a Republic function. This is a private function, but we have asked the Republic to help do it, and to help set the people's land free. Now, I don't get a cent for this, except for what I do in the seminars. I do get paid a little bit for this, but the process that we set up out there is not my process, and I don't get 1 cent from it. And I set it up that way intentionally.
Kelby Smith had mentioned that this was a train-the-trainers
Yes.
seminar.
Yes.
So would it be convenient for you if we went back to our states and held our own seminars in charge?
You have to go through Tom and get his consent to do that.
I'm sorry, we have to call who?
Tom. He is the man that's in charge of that. I am I'm confident that he is going to want to put some trainers out there very quickly, but he's going to want to know that you know how to train first. He's not going to just...
Physically located.
He's in South Carolina.
Thank you.
Okay. And
That too.
yeah. Well, we're not going to just tell everybody to go out and train people, because not everybody can train people. Some people are not... I have a different way of looking at things. I think in linear terms, step by step. A, B, C, D, E, F, G. Some people can't do that. And if you can't do it that way, you can't teach people that process, because you'll skip around and miss steps. And I'm so simple-minded, I just have to do it that way. But I have to go step A through Z, because I don't think that way. But anyway, that's how you have to do, and how you have to think, and how you have to train, because you can't assume people know anything. That's the reason I take you into the law. That's the reason I take you into definitions, and we're going to get into some of them in a bit. And I give you a step-by-step program. And we're even going to show you how to put the documents in order. Every time they all do the same thing, every time. So when they get to the Records Bureau, all they're going to do is scan them and put them on record. They're going to return the originals, they're going to file the notices, and return everything to the owner. And that's how it's got to work, because if you don't, they're going to get backed up in a hurry. They're going to get backed up anyway, but they can get buried real easy. And so, anyway, that's why we have been making weeks and weeks of preparation just before we even trained you. Because we didn't want to get started until we were ready to get started. We're ready to go. Okay, our stuff is up. By the first of the week, everything will be ready to flow. So we've got that going on now.
Did you get the information on Republic Notaries?
I did. He has not sent it to me yet. I'll probably have it today, but I will give you a contact information today for that as well. Wade is supposed to email me. He's probably working on it right now, but he's also doing some seminars this week too. He's training. He does Christian seminars and financial seminars as well. And he was training. He was on his way into the seminar yesterday when I called him, but he said he would get it to me. So he's real busy too. But he has got it together, and we do have the bond, the company set up ready to bond you, and we will get that information all. What we're going to do is post everything on Freedom Yell as well, so if you have any questions, you'll be able to go on Freedom Yell, and it'll explain it all to you, okay? freedomyell.com. We'll have all the information. All right. Now, first of all, I'd like to, for those of you who have never seen a land patent, y'all just pass these around if you will. And that's a copy of an actual land patent. Now,
We can take one?
Yeah, just you keep that. That's for your, just for you to look at. That's what they look like. They're very simple. Now when you order one from the Bureau of Land Management, I think it said 5 copies is $5 or something like that. It's not very, they'll send it to you on parchment paper, but that's about what it'll look like. Now a land patent was signed off by the President of the United States. Okay? When the land was acquired in this country, it was acquired by conquest or by treaty. There was some of it acquired by conquest, some acquired by treaty, and some by purchase. Louisiana Purchase was one of those instances, which I think that this was part of the Louisiana Purchase. I think Alabama, wasn't it? I think all the way to Texas, if I remember right. Anyway, I'm not completely familiar, but I think most of this area was part of that purchase. But anyway, the part of Florida was in it, and part of Louisiana, all the way up, I think, to almost to Texas, maybe, or it might have been to Texas. But anyway, it was a big tract of land. It was purchased from the French. Actually, I think Napoleon, maybe. But anyway, we bought the land. We purchased that part of the land. But some of the land was taken by conquest in this nation from the Revolutionary War, taken away from the Crown of England. Okay? Now, when the government came into all of this land, it was considered public property because we were sovereign people. Okay, so that means the government couldn't own the land, it was owned by the people. So what they did is when the people would step up and say, I want some of this land, the president would write them a land grant. Now land grants traditionally are 160 acres. That's usually what a patent covers, is 160 acres. What they did is they broke it down into 4 sections most of the time of 40 acres each. And after the Revolutionary War, they didn't have the money to pay their soldiers, so what they did is they gave them 40 acres and a mule. You ever heard that statement? That was true. That was actually for payment for their service in the military. They also did some of that after the Civil War as well. So, and probably other times during the country's history it was done. But I know that they did it. And it actually, that was part of their payment for their service in the military, because they didn't have the money to pay the soldiers. And so they gave this land, which was already public land, they just granted it to the people. Okay, now when the grants were given to the people, the law says that the government releases all title and all claims upon this land completely. That this absolutely belongs to the person that the land grant was issued to. And they have the full right to do what they want to with it. And nobody can encumber it, nobody can bother it, nobody can take it. They can't even do eminent domain on a patented piece of land. They can't come and tell you, we're going to build a U.S. highway through your property. They're going to have to go around your property if you've got a patent.
Even the Queen or the Pope?
Nobody. Well, especially the Queen and the Pope. They don't have any authority. Now I better watch it. I'll get in trouble. My buddy John, he's Catholic. He's a good friend of mine, but boy, he might get me if I mess with the Pope a little bit now.
I'm still waiting for someone to come up with that Treaty of 1213.
That 1213?
Pope owns all the land.
Yeah, I was about to say something about that papal bull, and that's exactly what it was.
I'd like to
Bull.
see that one.
Yeah, that was the papal bull, and that's what I call it, bull. Nobody has the authority to own land except the people. And God gave them that He gave them dominion over the land. Now, we talk about ownership. And the truth, I explained that to you yesterday. We don't own land. We have the right to occupy the land all the days of our lives and use it however we see fit to our benefit, as long as we are stewards of the land and treat it properly. I mean, we're not supposed to destroy it either. That's part of one of the responsibilities of using the land. But we're supposed to pass this down to our next generation. That's our heritage. That's what we're supposed to do. That's our inheritance from our forefathers, and we're supposed to pass it down to our children. That's the intent of land ownership, what we call ownership, as much as you can own land. But in truth and reality, it belongs to God. All land, He created it. Who's got a higher title than that?
That's right.
But He gave us the authority to use it. And so when we talk about a land grant, even though we say the word ownership, in reality we're just here as stewards of the land. We're custodians of the land. That's all we all are. And no government is any different than that. They can't own the land either, any more than the people. In fact, the government can't own, they don't have the capacity to own it at all. The people have capacity to, more capacity to own land than they do. And in reality, God owns it all. So what we do is we actually use it. But when we talk about ownership in legal terms, a land grant shows that you have all rights and titles to that land to use it however you see fit. And the only thing that gives you that right is a land grant. We call it a land patent. And it's a patent because it's registered in the BLM, in the Bureau of Land Management. Now there are some private lands, and we're running into some issues with this in the 13 colonies right now. There are some private lands that were held that were never patented. Now we're working on that issue right now, so some of you, if you live in the original 13 colonies, you may find that they don't have a land patent for you. So we're working on that issue right now. The issue is who owned it? And if there is nobody that can step forward that shows higher title than you have, then you can declare ownership. And we're going to create the information to do that. We're actually doing the study. Tom and I was talking this morning actually about that. And he's studying right now on how do we approach that, and actually maybe we can patent the land to the people. I'm not sure. We're going to have to figure that out. But anyway, you can still go ahead with the process and claim ownership of your land. And we may have to tweak it a little bit if you have a private land. But we'll get that done. Now, if there is a patent on file, and there are many of them, most land is patented, and when you go to the BLM and you get that certified copy of that land patent, it says that this land was granted by the United States to this person, whoever it was granted to, and his heirs and assigns forever. How long is forever?
A long time.
And longer than we have to worry about, I can tell you on here, this earth.
What does it say in Black's Law about forever?
I don't know. You tell me.
I don't know.
I'll just say this, forever is long enough. I don't know how long forever is. I don't know how you define a new... Yeah, that's all I need it for. It's long enough. Okay. Now, that was signed off by the President of the United States of America. Now, what you've got to understand is that land patent, if you've got a chain of title down to you, it gives you the authority by the President of the United States to bring that forward to you. Now, what happened in the 1920s and 30s, we had a problem in America. You ever heard of the Dust Bowl?
Yes.
And then the Great Depression that followed? What happened is the farmers went bankrupt, basically. And they borrowed money trying to stay alive until crops got picked back up, but they didn't pick up for a decade or so. And so they all went into a foreclosure situation, almost all over the Midwest. Hundreds of thousands of farmers were going out of business. So the bankers decided to start foreclosing on all the properties, which they had the right. They borrowed the money, and at least back in those days they did. Today it's different. But back in those days, in the 20s and up in the first part of the 30s, if you borrowed a loan, it was hard money lending and you had to pay it back. That's not the case anymore. It's changed. But what happened is all of the farmers held patents, because that's how land was conveyed before the mid-30s, mid to late 30s. It actually was not done away with. It was just kept away from the people. The attorneys changed the process and told them this is a better way to do it. Yeah, who was it better for though? But what happened is the banks decided, well, we're going to have to take this property. Well, in the Constitution it said that any issue that required involved $20 or more, you had a right to a trial by jury. So the farmer said, well, we got a right to a trial by jury. So what did they do? They took it to trial and selected a jury. Who was the jury? The farmers. And the farmers looked at each other and said, if we let them take Brother John's land over here, it won't be long they're coming after ours too. So they said no.
I don't believe
So the juries wouldn't let the banks take the land. And under a patent, they could. So the banks got together and they figured a way to try to circumvent the land patent. And by the mid to late 30s, they didn't issue patents anymore. They kept that a very hushed up secret. And what they did is before that, when you did a land patent, you couldn't pay a patent, you had to pay a tax on the property, on the total amount. It was just a transfer tax or whatever they called it. But it was a tax. And just like you do today when you buy land, if you got the total amount on it, you have to pay a tax on it. It may be just a few $100, but it's still a tax for the transfer of that property. You pay that to the county. Okay? Now, what the lawyers did said, listen, we're going to save you that tax money. So what you got to do right here, and this is legal, you can put $10 in other good and valuable considerations instead of the amount of the property, and you don't have to pay that tax. And people say, well, that's cool. Well, that's saving me some money. But what they didn't realize is they were going underneath the law, and they were not meeting the $20 requirement. See, if the farmers would have been educated and understood that if it was if they would have put $21, they'd have still been covered by trial by jury. How many of you have seen, there was somebody showed me a deed just yesterday, and what did it say on it? $10 and other good and valuable considerations.
And they knew it had to be 21.
And they knew it. That is the reason that was done. And they did it, so well, this is going to save you some money. And all the lawyers started doing that. And most all of my folks bought their land that way. And it says right there on the deed, $10 and other good and valuable considerations. Now a judge can rule in a foreclosure. And that's how they got around that. So now you know the rest of the story.
Now I know why the 13th Amendment was put in.
Yeah, now you know. That's why they pulled all that stuff out. They didn't want it exposed what was really going on. So now, you don't have the right to a trial by jury in a foreclosure if you've got that kind of deed. So what we've got to do now is we've got to correct all this stuff. Now, for you can bring the deed that you have now. This is an issue that we're going to run into. Some of you are going to run into. Some of you, and I've already talked to you, your property is in a trust. You've got to get the trustee to deed that property back to you before you can do this. If you have a trust deed, you have deeded the property. You have conveyed it to somebody else. So you need to get that corrected before you do this. A trust deed means you have voluntarily conveyed it. You have that right. You can do that.
How can,
What if it's a family trust?
It still belongs to the trust. It doesn't belong to you.
What
So
if you control the trust?
that just means you're the managing director. It doesn't mean you're the trustee.
Gotta go out of my family trust?
Back into your name before you can bring a patent. A trust cannot have a patent. It's a corporation or business. No, the trustees can still move property in and out of the trust regardless. The trustee can. I don't know if the grantor can or not. I'm not sure. It depends on how the trust is structured. Usually the trustee is the one that has to do the changes and do all that stuff. And it depends. There's many structures of trust. He may have to go to he may have a board that he has to go to get it approved too in some trusts. There's all kinds of structures for trust. Now I'm not a trust expert by any means, but I know that if you're a managing director of a trust, you don't have any authority to move anything.
But you're talking about a trust deed rather than
trust. Yeah, that warranty deed is different.
Be who, the bank?
Some people do a trust deed to the bank when they do a mortgage.
So how do you get that reversed?
Well, that's a question you're going to have to go find out. I don't know the answer to that.
wow. Are we going to run into people that are going to have that situation?
You're going to have people that have that. So but the trust deed will have the bank on it, not them. If it's in there, it'll have the bank on it because they have given it to the bank.
And so the banks aren't going to give
The
it.
bank can't do it. And so what they're going to have to do is they're going to have to find a way to get it out of their name. Out of the bank back to their name, yes. They're going to have a deed that has their name on it to do this.
How do we know if there's a trustee on our property?
It will be recorded. at the courthouse.
As a trust deed rather than a warrant.
As a trust deed rather than a warranty deed.
Across the top.
If you went down to the county, like I did when I did the deed acknowledgement a couple months ago, if I asked for a warranty deed on the specific land, would they have said it doesn't exist if there was a deed of trust? Because I need a warranty deed.
No, they will probably say there's a deed of trust, that it will be recorded.
Okay, so let's say there was, and so, you know, again, going back to the fact that a corporation or a trust or all that stuff, they can't own the land. If you were able to go back, because all they gave me was a warranty deed, so I don't think there's a problem.
If you've got a warranty deed, that's all you need.
Because if there was a trustee that happened after,
It would have to be recorded at the courthouse too to make it valid. If you did a deed of trust to a bank, it will be recorded.
and they would not have given me a warranty deed.
No, because that supersedes your deed, and the bank would have it on record. Okay? Yes.
What is a special warranty deed?
That I don't know. It must have special covenants in it, is all I can tell you. Now, there are all kinds of covenants that go in deeds. We had a church one time that had a warranty deed, or had a special deed like that, and it had covenants in the deed. And one of the things that was funny, it couldn't be sold to be a juke joint. That's what it said right in the deed. Nobody could use that property. You couldn't sell it to anybody who was going to build a juke joint. A juke joint is a bar. And that's what they call them in the South. Yeah. I mean, it's right on the deed. So when the church got ready to convey the property, they had to make sure that it wasn't going to anything like that, because we couldn't sell it that way. It's in the deed. Yes.
Sometimes a warranty deed will be called a general deed.
Okay. It can be. There are many, many different names. There are as many names of deeds as there are people in this room.
Since I've been down here, I got a text message from somebody up in Wisconsin, and they said that they found out that they have a trust deed. I want to ask your opinion on this, Tim. You know, first in time, first in line, if they were able to access a warranty deed that was on record, and we know that a deed of trust, they wouldn't be able to acknowledge the deed the way the deeds are set up. Wouldn't there be first in time if they went back and were able to find a warranty deed, and being a flesh and blood living man or woman, if they were to acknowledge that deed and do this process, wouldn't that supersede any deed of trust?
No, it wouldn't, but you'll have to deal with the deed of trust issue. If it is literally in the bank's name, and I don't know how they may do this all kind of ways. I'm not an expert on it, but I do know that if you have a deed of trust, you've conveyed your interest in that property to that institution or that bank, and they may even have the thing in an officer's name, or I don't know how they do it.
Isn't that how they're getting away with all this stuff in California?
They get away with a lot of
Isn't that
stuff.
all deed trust deeds and stuff?
It could be. Could be. Yes, Tim?
I contribute something
Sure.
here? Depending on the contract that you have, it's likely that you can reassign a trustee. What the banks count on is you wanting to get the money so you can get your house, your land. All right? So they provide for your convenience the name of a trustee, and you do the paperwork and you create that deed of trust, the trust deed, okay? What you might consider at the time when you did that, you didn't realize what all was going on, you didn't realize the fraud of the bank, you didn't realize
That's what I
you
was
didn't
going to
owe
bring
the
up.
money. So what you can look into doing is assigning a new trustee who knows what the real deal is, and then have that trustee do a process requiring that anyone perceiving that they have an interest in that property bring forth proof of claim.
Yeah.
If you can't bring forth proof of claim, then the trustee position is satisfied, and he can release that trustee, that property to you, and he can document that process, and he can use a negative averment process as a trustee.
Yes, you basically just default on them because they're not going to respond.
Yes, so you do that without ever going to court, and you get the bank and the stock.
Am I correct in understanding that if they sold you your house and gave you a trustee, that you were the grantor? And if you read it, there are privileges that the grantor has.
Yeah.
If you read yours, not the theory, but read yours, it may say that the grantor has the right to change trustees. If he does, you make
And most of them do.
Uncle Tim the trustee, and then the trustee can deed it to
Right,
you.
exactly. And that's one of the ways you can do it. The thing, you can attack all of these things on fraud because they are committing fraud. We know that. Because they never loaned you any money and the trust deed was given in consideration for them to make you a loan, and they didn't do that. So there's a number of ways to attack this. That's something that, but Mark is exactly right. You need to read, and there are so many different ways that they approach this. I don't even claim to even be able to teach on that because I don't know. You're going to have to read your particular contract and follow it.
Yes. Whoever's a trustee, don't have them, if someone makes you a trustee in a situation like this, you better follow the trust indenture.
That's right.
Okay? If you do not follow the terms of the trust indenture, and you deed that property, that land, to what you perceive as a rightful owner, you put yourself at great risk.
That's right.
In the law. Not just color of law, but in the law. Okay? You violate a contract there.
You've got to read.
So you've got to read the trust deed and the indenture to see what you can and cannot do. That's why I don't teach that, because there's probably hundreds of variations out there, and I don't have any idea what yours says. Donna.
Tom taught us that once you acknowledge the deed, so it doesn't matter if there's deeds beyond your deed.
Right.
Because anybody can go back, can acknowledge, but it's first in time, first in line.
Right. Well, when you do the patent process, that's true, and when you acknowledge that is true, but you still got the trust deed issue. Some do have trust deeds.
I'd like to address something regarding that notion. That's right in certain circumstances. But if what you have there is a chain of contracts, right? You can't just ignore new contracts. All right, so you have a deed that's on the record with the appropriate office, clerk, and you have all these other contracts that have occurred. You can't just, that are not reflected on that record, you have no right just to go back to that record because that's the only thing on the record, and ignore everything that's been done in the meantime. You need to satisfy all of those contracts from the time it was last recorded up till now, and if in that process there have been quitclaim deeds and it's somehow gotten into a trust, you're going to have to get it out of the trust. So there are only special circumstances when you can take that that's recorded and use that to bring forward a land patent with ignoring other things. Very carefully.
Yeah, you have to.
That, if you don't,
You have to follow your agreements.
Fraud, and they can defeat your land patent.
Yes.
The land patent will not be worth a tooth in the wind.
Okay, so what do you do with the sheriff's deed from a foreclosure? That someone bought your property on a sheriff's...
Did you consent?
No.
They didn't have the authority to sell your property.
Okay, so but do we have to go back and satisfy that as Tim is...
No, you do not.
No.
Okay.
A sheriff's deed is not a deed.
In that,
Okay.
which vitiates even the most solemn agreement.
A sheriff's deed, and it's been ruled in court. I'm going to give you guys, I got, any of y'all want these, you can have, there's probably over 100 cases, I think. I don't even know how many is on here. If you want these, this is case law on land patents. And it says that a sheriff's sale cannot even issue a lawful deed.
Really?
They can't do it. It's not considered ownership. If anybody ever challenges it, they're going to lose because they don't have the authority to sell that thing for taxes. When you bring the land patent forward, it supersedes all, it overrides all of that. When you bring that land patent forward, you have the ownership. They do not have the right to own it. Yes?
I know someone who lost her place to a sheriff's sale and somebody else has already moved in it.
Don't make any difference.
Okay, so she can go back and...
Yes, unless she signed consent. Now that's the key. If you have somebody that has signed consent, they can do it.
Consent to...
To let them do it. And if they didn't, if they told them, no, I'm not consenting to this, they can go back and take it.
We have a property that has a maritime lien on it. The lien is still there. They ignored the lien. The sheriff sold the property.
So you protested, didn't you?
Absolutely.
Okay, so they don't have any authority. The land patent will put the deed, the patent will bring the deed up in your name, and you will have the patent in your name, and you will have the chief title, and if you take that action to a federal district court, they are bound by law to uphold your patent, period. Because you did not consent. Yes?
Non-judicial states, are those always where they have the trustee sales? Isn't that what they call that in non-judicial foreclosure states?
Yeah, trustee sales, yes.
So those would be deeds of trust then probably, wouldn't they?
Possibly, yes.
Could they have do you think they could have a deed of trust? Do you know of anything in a judicial state?
You just have to read everybody's got, it's so much varies across 50 states, I wouldn't even know how to answer that. They may have, very well have a deed of trust. In California, it's real popular. Real popular. Yes, ma'am.
Many people just think they can give property back to the lender in lieu of foreclosure, and they think it'll save their neck. But
No, it won't. No, it doesn't. Well, see, the problem, the whole issue here is the bank is not the lender. They claim to be the lender, but in reality, you are the lender. They've done a role reversal on you, and that's how they get you into these contracts. Is they lie to you. What is an unconscionable contract? Can anybody say the word void? The law says it's void. If they did not give you full disclosure in the contract, and there's not a mortgage out here in any commercial bank in this country that has had full disclosure, I bet. I don't know of one. I never heard of one. Yes, sir.
Tim, the Black's Law, 6th edition, on anybody that's going through this, you can get a hold of the 6th edition, go to page 1550, look at validation of contract, and this is exactly what we do. It says that
That's correct.
all elements of a contract must
be met.
present.
That's right. And all right, let's talk about some of those elements. What are some of the elements? They got to have the parties listed, don't they?
Acceptance, 15.
Okay, offer has to be given. Now, first you got to have the parties. You got to identify who the parties are.
Right.
Okay, then you have to have the offer. Okay, you have to have acceptance. You have to have consideration. Consideration, I call that consideration or consummation of the contract, because until you pay or make some kind of exchange, there's no contract, fulfillment of the contract.
And all these, there's only one person signs that.
That's
Right, and see, and legal signature is one of the elements of a contract.
right.
Another thing in a contract that most people have never even heard about is a meeting of the mind clause,
Right.
which says that anytime that they sell that to someone else, you have to be in agreement for them to sell it.
Right, and they'd never do that.
They have never done that.
Yeah, and that's all part of full disclosure. All that's the part involved in full disclosure, and full disclosure is not done on mortgage loans.
You often hear the term patent pending, patent applied for. Is this a case similar to that, when we are applying for the patent, but yet we haven't finished the paperwork?
Yes, you can say,
Statement, patent applied for?
yes, you can, absolutely. We do a public notice stating that the patent is, that we are updating our patent. We don't say patent applied for, but because, actually that's not exactly true, John, because the patent has already been issued. When you're applying for a patent, you're waiting for it to be issued. This patent has already been issued, so you're just updating it, is all you're doing.
Okay.
So it's already a done deal.
You say being updated, or?
Well, I say it's being updated. That means that you have, because we have to wait 60 days for somebody to challenge it legally. Okay, and that's why it's being updated, and it has not been completed. So you can go ahead and get that public notice out saying, anybody has a claim, come forward. We got the notice for you already done. Now that public notice will be done by the homeowner. You just give them the form and they go out and do it. You're not responsible for that. Remember, let the homeowner do their own work. Don't you get involved in doing their work for them, or they will let you. I promise, John.
60 days going to be required?
60 days. You have to leave that out there for 60 days before the patent is finalized. in the event that anybody can come forward with a claim. If they don't come forward with a claim in 60 days, it's done. They can't come forward after that.
Where's that 60-day time frame? Is that in law somewhere?
Yeah, it's in the law, yes.
Is that all states?
It's considered the standard across the board, yes.
Yeah, now, let's just say the notice is up, you got your 60 days, it's posted, okay, say your bank then, for whatever reason, notices that you are doing this.
That's fine.
Okay, so they make the claim, so what is that process gonna look like?
Well, let me ask you a question, okay? If they make the claim, are they going to be able to prove that they paid the taxes for 10 years and that they have a deed in their name?
No, they can't do that.
They don't have standing to bring claim. So what are you going to send them? Say, you don't meet the qualifications to bring, you have no standing to bring this claim, blah, blah, blah. Have a nice day.
Okay, so
And if they persist and they can bring you to court, you go to court and say, they didn't pay the taxes for 10 years, they don't have a deed, and they didn't occupy the land for 10 years. So they cannot make an adverse possession claim.
Trump.
They're done. So the patent will stand simply because they don't have standing. Did you see the code that I read to you yesterday? I showed you? Okay. It's very clear, and it's in all states. And it might not be exactly like it was in Alabama code, but it's very similar in all states.
So it's like a shield. I mean, when you notice that, they're not going to come near that.
I'll promise you, they don't have a lawyer in any bank in this country if they wanted to go into a federal district court with an adverse claim against me. I'll promise. That'd be more fun than going to Disney World.
In the documents that you have listed here, is there any example there as to how that notice should read?
Yeah, we have the notice already created for you. Guys, we already done the work for you, man. When you see the documents here in a bit, you'll understand. We got it. We got it all together. We just forgot where we put it.
That's my story.
We got everything already done. We've done a lot of work to get this organized so that it'll be easy for you to do it. And we'll show you this afternoon, step by step. Today, it'll be here in a little while. We'll get into that. But I'm making sure that you have a legal footing and legal understanding and legal knowledge to understand they can't come at you with an adverse claim and abide by the law. It's impossible for a bank to do that. They can't do it. Because the law says they can't do it. Not because I say they can't do it, but the law says, and I read it to you right out of the current Alabama code yesterday. There it is right there. We'll go back over it again just to make sure you absolutely understand. And this applies in your state too.
Is that on the discount?
Yes. Now, what are the requirements for an adverse possession? It says, A, adverse possession, excuse me, cannot confer or defeat title to land unless, that means they've got to meet these conditions. Okay. The party setting it up shall show that a deed or other color of title purporting to convey title to him has been duly recorded in the office of the judge of probate in the county. And that's what we call, that's clerk's office or property office, land office, whatever you call it in your county. They got many names for it. And it has to be there for 10 years before the commencement of the action. Bank just failed the test.
And it's not one or two or three, they have to have
all three.
One,
exactly.
two, three.
It's, yes. He and those who through him claim, and they write funny. These are lawyers. They write funny. He and those through whom he claims shall have annually listed the land for taxation in the proper county for 10 years prior to the commencement of the action.
Comma.
Strike two. Bank didn't do that. Number 3, he derives title by descent, cast or devised from a predecessor in the title who was in possession of the land. Strike 3. They're not in possession.
We got it now.
Okay. And there's even more in there. But what I'm saying is they've got to meet all of these conditions to even bring an adverse claim. You remember what I told you? The very important part, that if you don't understand anything else I have taught you, is standing. If you don't have standing, you cannot move a court. It's unlawful. You cannot do it. It's absolutely impossible in law to move a court. And that means to get the court to take an action for you or do an action for you. You can't make them do it. You can't do it. They are barred from doing it in law because you don't have legal standing. The bank has no legal standing. And that's the proof of it right there. This is right out of the current Alabama code. I went on their site. I downloaded it from their site. And in your state, because we have uniform codes, because we have what? A Republican form of government in this nation. All of the states come into union and they have uniform codes. So your state is going to be similar to this. It might not be exactly like that, but it will be similar to that. So you need to go to your codes and read about land ownership in your state. And then you can go into court and say, "Excuse me, Your Honor, the bank does not have standing to bring this adverse possession claim." And how would that be? Well, code number 6-5-200, section A, 1, 2, and 3. And I quote and read it to you on the record. Where are they going to go? See, ignorance is what's killing us, guys.
So even a straw man could challenge every foreclosure just based on this?
Absolutely. I don't understand foreclosures. I don't understand why we're letting them do it. We don't have to.
It's because we consent.
It's because we don't know. It's because the people are ignorant. But you're not ignorant anymore. Now you know. You know, as I say, we know where their goat is tied. The old preacher Noble used to tell me all the time, he said, "Brother Tim, don't ever let the devil know where your goat is tied." I said, "Why is that?" I used to call him Papa Noble. I said, "Why is that, Papa?" He said, "He'll steal your goat." So, y'all need to remember that we know where the goat is tied. Now we're going to go get their goat. Okay? And it's in the law. Once you understand the law and understand the basic principles of the law, they don't have any standing. And you can beat them up in court every single time because the judges are playing on your ignorance. And I'm going to tell you how they do it. You haven't taken possession. We talked about this a little bit yesterday. You have not taken possession of your property. So the judge is placed as a trustee in your stead to make the determination on this property. Well, the bank is making a claim. Do they have standing? No. Well, you don't either. You're coming in there, like I said, yapping. You ever seen one of these little yapper dogs? I got one at home, and that little thing, sometimes I could, it'll bark at the air for no reason. Just yap, 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 yap. And it don't know when to shut up. And it don't matter, you grab that one by the ears and talk to it, it don't help. That one's retarded. That dog is absolute. I inherited that dog from my brother-in-law and sister-in-law that left him with me. And all I wish they would let me know where they live so I could mail him home. But anyway, we take care of the little fellow and all. I feel sorry for him. He's retarded and he can't help it. But anyway, that's what we're doing in court. We're just up there yapping and irritating the judge. That's all we're doing because we don't have standing. Once you take possession, once you do this process, once you take delivery, acknowledge, once the deed, you accept the deed, take delivery and accept the deed, you're not yapping anymore. They can understand your language. I say that dog all the time because we don't have a connection. We don't. I've had lots of dogs and I had connections with some dogs. But this dog, there's no connection. And what I tell, Brother Tim gets to laughing at me sometimes. I tell that dog, I said, "You got to quit speaking Japanese to me because I don't understand it." And it don't understand my language either. But Anyway, that's what we're doing in court. We're speaking Japanese to the judge, and he's just sitting there looking at you like you're crazy. He don't understand, because you don't have a claim. And the judge is doing exactly what he's supposed to do. And then we go, that crooked judge. The judge didn't do anything wrong. He did what he had to do. He did exactly what the law requires him to do. We are an imbecile to him because we don't understand. And it's not his job to teach us. In fact, he can't teach us.
This is amazing.
And this is how it works. Once you take possession, all of a sudden you have standing to speak. And guess who doesn't? Now the bank's over there yapping. They become the yapper, and now you've got standing.
And the judge has to...
And the judge has to recognize your standing. See, this is how the court works. The judges are doing exactly what they're supposed to do. And once you understand those concepts and understand how to apply those concepts, and it's very simple. Take possession of your land, and the owner has showed up, and now the owner can speak. And standing in a court, and the bank can't. Because the bank does have, do they meet any of these requirements?
No.
Not one. So how are they going to have standing? So all you can say is, well, Judge, I'm the owner of this land. Here's my land patent. I've taken delivery and accepted my deed. Here's the documents. I've done my public notice. And I'm here because the bank is trying to steal my land. And the judge is going to look at that, and all of a sudden he's going to be between the proverbial rock and a hard place. If he moves in favor of the bank, he's going to get sued by you, and he's going to lose. And he can probably be prosecuted. You could actually prosecute him. I did. I've got a criminal indictment against a federal judge right now. He may have retirement in the Gray Bar Inn before it's over with, and he deserves it. Because I wasn't ignorant, and I stood there and I proved to him. But yet he kept moving anyway. So he committed crimes, and the Department of Justice has agreed that he committed crimes. And it's not going to fare. He's not going to fare well. But the bottom line is this: as I created standing before I went in that court, and that's what you've got to do. I think you had a question.
Actually, I think you just answered it, which was the landowners have to go and accept their deeds before we can process this.
Yes, they do. And all they got to do that is write accepted, sign it, and date it on the top of the deed. That's all they got to do.
And are you saying then we have to stand before we can run? We have to stand before we can run?
Absolutely. You've got to have standing. You've got to have standing. Because the judge cannot hear you. Have you ever seen a judge do this? I've seen him do it several times. That you file a paper in the court and he turns it upside down on his left-hand side and says, I can't see that. Well, you know what he's telling you. You don't have standing to show him that. Okay? And this is one of the ways they do it. The IRS is really, they're very crafty about this. When you go into court with the IRS, and we're not going to teach about IRS today, but this is just something, this is a freebie for you. When you go into court with the IRS, you can go in there with that stack of evidence that high to prove you're not a taxpayer, but you know you're going to go to prison anyway? And why do they do that? How can they do that? Because when you went in there, the judge says, how do you plead? Well, I'm not guilty.
Oh,
You just entered their jurisdiction.
You just entered their jurisdiction, but that's not all you just did.
You just admitted.
You admitted that you're a taxpayer by doing that. Okay? Because you said you're not guilty. You didn't. What you should have said is, I'm not a taxpayer. I don't know the nature and cause of the action against me. How in the world can I plead? That's what you should be saying, but you're saying not guilty, so the judge, okay. So now when you go to court, you can take this whole stack of evidence and set it on the judge's desk that says I'm not a taxpayer, and the judge says, I can't see it. The only issue before that court now is, did you pay the tax or did you not pay the tax? That's the only issue. You should have pled, I am not a taxpayer according to Title 26 of the U.S. Code, and you can't prosecute me under Title 18 because it was never lawfully passed by Congress. Then they're going to say, oops. And then they're going to have a huddle with the prosecuting attorney. And if they got any sense, they're going to tell you to get lost. Because if they don't, you're going to create then some real difficult stuff to deal with. The bottom line is because we don't understand these little procedures is why we get beat up. Now, what I'm telling you is when you have a problem with a bank and they're bringing an adverse claim, Wyatt was saying, well, you know, I don't understand this adverse claim. I'm the owner. And the bank can't prove ownership. They don't have any standing to even be here. What in the world is this guy even talking for? I'm the owner here. You don't have any claim at all. You don't have standing to even make a claim. The law says so, not me. That's going to put the judge in a tight spot. Because if he is being paid by the bank, which is often true, to take your land, better hope they paid him good, because it's going to cost him. Because if you prosecute this guy for violating the law, he won't go over. Most of them will not violate procedures like that if they know that you know. So when you go in there and you claim the standing and show them, not claim it, but prove it that you have standing by bringing all your land patent documents forward in a court, if the judge has got half sense in one eye, he's going to tell that bank to go take a hike. Because it's going to be a short career for him if he doesn't. Because you got him nailed. You got him nailed. And he has no way out. He has put himself into a box, and all you got is nail the lid shut. Yes? Had a question? Yes, sir.
Could you explain the difference between acknowledgement and acceptance?
Yes, an acknowledgement basically means that somebody verified that the grantor signed the deed. Okay, and that's usually done by a notary. So the acknowledgement is usually done when the grantor signs the deed in front of a notary, or witnesses can do it as well, but that's where it's acknowledged. But the other two things is taking delivery. And remember what I told you at the closing? The lawyer, he'll open that folder up and he'll say, here's your deed, I'll get it recorded and I'll get you a copy. You didn't take delivery. What you should have done, and next time you go to a closing, just do this. Say, can I see that for a minute? And write accepted, sign your name and date it. And he's like, oh, wait, you can't mark that up like that. You can't write on that. I said, sure I did. It's my deed. I can write on it if I want to. It's like I went down to serve the sheriff down here the other day, and I got down to the duty officer at the jail. I said, I need to give this to the sheriff. He said, I can't take this. I said, sure you can. You just did. I said, have a nice day. You've been served. And then Tim Pledger, this was classic, he said, y'all have a Merry Christmas now. You don't need to do that.
Can we, and how, I'm trying to figure out how is that done? How can I do the part?
All you have to do is go, who is the trustee of your trust?
Repeat the question for those that are actually...
Okay, she's wanting to know, how do you take the land out of a family partnership and put it back into your name? Who is the trustee of your trust?
We are. We all are.
Okay, well then all you got to do is agree as trustees. Everybody create a deed and deed it to you or whoever you want it deeded to in their name, and everybody sign it. And sign the deed.
And sign the deed?
Yeah, sign the deed.
Can you not at that time sign the deed and write on the acceptance then?
Yes, absolutely.
And
can you carry some more weight if Lisa and her family originally had 4 parcels of land?
Yes.
Individual names. Their dad created a family partnership a number of years back. Couldn't they go create a new agreement to dissolve the family partnership?
Yes, absolutely.
Personal name. We also get an attorney to redo the deed when we go to closing.
You can do that too. Sure. Yeah, sure you can do that. But when you go to the and you got to go by the terms and conditions of your agreement. But if you do that, you can certainly go do that if it's allowed within your agreement to do that. And then the property can be put back in your real names. Okay, but when you go to the closing, if you could do that, and you got to go read and make sure, get the attorney to research it or whatever if you got one that you trust. We share that for pretty much. I do know a couple that are good people out of hundreds. But anyway, you've got to go by the terms of the agreement that's set forth. And as long as you meet the terms, there's no fraud involved, because if you do anything that's fraudulent, they will overturn your land patent. So you make sure you've got the legal standing to move forward to do what you're doing. And you may need a legal professional to help you with that, to dissolve the trust properly. And then when you come to the closing and they show you the deed,
I'll ask to see it.
tell them you want to look at it. And just go get you a big pen, and I'll use a blue pen because it shows up good. And big letters, I'd write accepted right across the top of the deed, and then I'd sign my name and date it. You just did. Because you can't accept it unless it was delivered, so that's already covered. And then I've got a form that's called Grantee Assignees Update of Land Patent that explains everything you did right there, and I'll show that to you in a little bit. Yes?
If you have a house that's been foreclosed on, the deed is in somebody else's name now, what do you do in a case like that if you have a house that's been stolen by the bank?
Did you protest it?
Well, I haven't had that happen, but I'm presuming that...
Well, okay. You got to understand that you have the right to sign away whatever you want to do. Okay? If you've signed agreements in a foreclosure and you've signed agreements and just gave up and walked away, you've given up your rights. Okay?
Even if you didn't know that that's...
Well, you can always come back on a fraud thing and challenge it. But it's a lot harder if you protested, like most people protest the foreclosure, and they can show they've done anything to protest it, that means they did not give consent. And that's all you got to have to show you didn't give consent, because everything they do is on your consent. And if you don't give their consent, they don't have the legal standing to do what they're doing. And and they don't have. But some people get fed up and they just go down and sign. The bank says, well, I'll give you $2,000 just to walk away, and they go sign an agreement, and they can't go back and do this, because that would be a fraudulent move. Yes, John?
In Michigan, one thing you do with the title companies, if you get a title policy, they just guarantee it for 3 years. They don't guarantee it forever. You actually have to do the abstract, which they charge a considerable amount more.
Yes, they do.
Where they go back to the land patent.
Yes.
But in Michigan, just FYI, you're not guaranteed anything other than the price of the home by the title company. And that's only for 3 years. So a lot of people don't know that. And they'll close a house based on 3 years. You may be in for some real surprises if it's not done right.
That's correct. You got to make sure you're within your legal standing to do any of this. So make sure you don't take anything for granted. Read your agreements. Make sure you abide by the agreements. One thing you got to understand in law, that if they're doing anything that is unlawful, and they usually are, they always have to give you remedy. And it's in there somewhere. All you got to do is find it, because they have to. If they don't, it's fraudulent, and you can put them in prison for it. And they're very careful about that.
I just want to ask you a couple questions in regards to the public posting before I forget. 2 things. First, when you go down there with 2 witnesses and say you want to take a picture of your posting and whatnot, how often do you have to go down there? I mean, what if somebody pulls it down?
Doesn't matter. That's not up to you.
So you just go down there and then just the one time, and then come back?
And I would take the 2 witnesses back with me to show that I took it down. And that's when
when you get back there after 60 days.
Just put it back up.
I post it again.
That's right.
Well, if you put it in the post office or the courthouse bulletin boards, they lock them up. Then can't nobody come just take it down.
Oh, I got you.
Yeah, they have a lock on them.
And then I know you said at the last webinar you can't put it on micro, but
I don't think that would be legal.
I know, but I mean, how some of these bulletin boards are kind of small, so can you is there a requirement in law, you think, about the size of the print, so that you can, maybe instead of having 8 by 11, it could be maybe 4 by 5 or something?
I don't know. Most courts require about 10 size font. Most of them do. But there are some requirements where they go as low as 6. You'll have to just see. I don't know.
Does it have to be a legal size paper, 8.5 by 11, or
Nope.
you just cut it out as long as the font size is the right size?
I don't know. You'd have to find out about that. I don't know. There are so many variations of this across the country. You need to find out in your local area what's required and follow those requirements exactly.
Typically, I think on the federal rules of procedure, they require font 12, double space.
Yeah. That's for court documents, though. I don't know if this would be considered that. Yes?
In Oakland County, anyhow, most of the counties I've been in, you're not allowed to take a camera in there. They won't even let you take your cell phone in there if it's got a camera on it.
Where's that now?
Oakland County.
In the courthouse?
Yes, sir.
Even in the front door?
Camera.
That's where y'all, I know I don't like Michigan, some of it.
They're very explicit about that. You know, they won't let you take your guns in either, too, and I can understand that.
Yeah.
But they won't let you take any camera or recording device.
Yeah, they don't let you take your Uzi in down here either.
But you know, President Turner, the process is costing the homeowner,
Listen up, guys.
the process is costing the homeowner a reasonable amount of money. I think I would just get for each county what's required, give it to them, let them take it to the paper, have them get an affidavit from the paper.
That's right. Well,
It's much simpler.
yeah, that's right. You need to know what the requirements are in your area. You need to know that. That's really
We
good.
have a responsibility to
Well, I think you need to help the homeowner as much as you can. That's what we're doing here. Okay. Now, do you have any issue, any questions or any misunderstandings about standing? Because you've got to understand standing to defend these things. And don't think that you're not going to have to defend yours probably at some point, because the banks are not just going to lay down. If they did, man, this would go viral. It's going to go viral anyway, but they're going to try to block it.
How are we going to help our clients with standing and you know, we do the process, but if they have to defend it, where do they go for that?
That's a good question, because unless they got somebody that understands how to teach them standing, I don't know. You can share with them what you can, but take them to the law. Just take them to the law and show them. You know, people believe what they read. What you tell them, that's the reason I put stuff up here for you to see it in black and white. I don't just tell you about it, I show it to you. Because I'm not just up here talking patriot myths and garbage. I'm telling you what the law says, period. And I win every time I go to court because I know what the law says. And I won't go to court until I'm prepared and have the law in my hand. And I don't take it off the internet either. I go to the law library and get documented evidence of it. Right out of the law library.
For every state, you have, like you said, ready to go to hand it to them.
Absolutely. You can.
When it does come up.
You should have an information sheet about these basic principles for your homeowner. If you really want to do a good job and help the homeowner, educate them. Everybody that you educate is somebody else that they got to worry about. Because they're not going to fall for the lies anymore. And that person's going to tell somebody else. And that one's going to tell somebody else. And pretty soon everybody in America is going to hear about this.
Everybody can go online for their state government. They can download a copy of the state rules of civil procedure. And it will tell you in there, it'll give you all the definitions and everything, and will tell you all the requirements for notice, what you have to do to notice someone, and all these other issues that he's referring to.
Yep, that's correct. That's a good point. So it's a good idea for you to understand and go print your code out just like this, like I have for you. And go print it out and give it to them. Show them. So the bank, to bring adverse possession, has to do this, this, and this. It would take you 5 minutes to show it to them. And then they'll understand. Well, they don't own the land. They hadn't paid the taxes on the land. They don't have a deed to the land. So how in the world are they trying to take my land? You catch it on. Okay? That's all right. So we'll come on here. Okay. Now, I want to hand this out to you. This is a copy of the checklist. It'll be on your disc as well. Y'all will pass these around. Now what I'm going to do is we're going to go through the documents one by one. I'm going to show you how easy this is. This is so simple. The legal language is already there. You don't have to do any of that stuff. All you got to do is put the personal information on these forms. It's so simple a caveman can do it.
I resemble that before. I'm down right here. Oh, yeah, I did too.
Okay, we were talking about the steps of actually taking possession of the deed. This is the document that we created, and it just says, notice of acknowledgement, delivery, and acceptance of the deed. Isn't that simple? And it says, on this date, I, the name of the deed owner, that's whose name is on the deed, in the presence of Almighty God, did receive delivery of a certified copy of my acknowledged deed. A copy is attached to this document from the clerk or office where it's recorded. And you need to put that information in there. In the name of the county, name of the state, wherever you see red, that's where you submit stuff. While in their official capacity, I have lawfully accepted delivery and ownership of said deed, and accepted said deed, and returned the lawfully acknowledged, delivered, and accepted deed to the clerk or officer to be recorded in the public record. Therefore, thereby perfecting and correcting the deed without any intent of granting or assigning or selling or exchanging any right regarding said deed accepted by me, or regarding any property listed or inferred thereon to any person other than myself. And you put your name there. Man of flesh and blood, sui juris, sole owner. Isn't that simple? Now, did you make your statement? Did you tell them what you were doing? And what you do is you have that, you sign that, and it is notarized, and you attach a copy of the deed. Okay, here's the jurat for the notary to do right here on the next page. It's 2 pages. See how simple that is? Now you just fill in the blanks.
If we sold a portion of the land that's got the legal description on the deed, is that where we would?
You would correct that. You'd put that in there, and you need to put the all of that stuff in there, your agreements, the legal descriptions and stuff like that. Okay.
Tim, this part is for a de facto notary or must to notarize?
No, you can use our notaries too, but now the reason we did this, now it says that you take it back down there to the clerk to have it recorded. They're not going to record this. That's okay. That's what we want them to do, is not record it. Another maxim of law. When you go to the de facto for remedy, a lawful remedy, and this is lawful remedy, and they refuse your remedy, what does that do in law?
Places them in dishonor.
Does that, but it also does something that's very, very important. Gives you the authority to create your own remedy. Now what did we do? We created our own recording site.
Now you say we take...
It's a very important maxim of law. When they fail to give you remedy when it's requested as law requires, the law does require it, then all of a sudden we have the right to create our own remedy now.
Just like when the government...
See where we're going here? Okay, and you're right, they did go into dishonor. Okay, now in Title 18, and I don't know the exact size, 3071B, Section 3071B, I believe. I'm going from memory, so I could be wrong. But in Title 18, and I believe it's 3071B, it says that any clerk who conceals, destroys, or otherwise monkeys with, that's my term, that's not in the law. Anyways, monkeys with a record, or refuses to record a record, and it's got a whole list of things that they can't do, is guilty of a felony, and that felony carries up to 5 years in prison. Yes, sir.
That law was never passed by Congress, so.
No, Title 18. Well, they don't know that. hey, they use it all the time, man. And I understand, I agree with your point, but the bottom is they don't know that, so they'll lock the people up on it anyway.
Could you not file that as a notice of deed acceptance? And because the law states that the clerk has to file any notice.
Yeah, well, yeah, you could. You can make a notice out of it, certainly.
What if they file it?
Well, that's fine if they do. That's even better. But they're not going to most of them. If they get 1 or 2 in, they're going to get a call from the big boys and say, "You better not file more of them if you will keep your job."
So are you talking about just filing the deed acceptance separate from the actual land patent?
No, yeah. This is the first thing that they do. They go down here, and the reason we want them to do this is very simple. What we want to do is we want to have 40 or 50 people in your community go down there and have them rejected. And I want every one of them to take at least 2 witnesses with them. And I want them to do affidavits stating that on such and such a day, I, John Lee Sovereign, went to the courthouse with Jane Lee Sovereign, and we went to record a lawful document in the records, and the clerk refused. And I need about 50 or 100 affidavits stating that on that clerk. And then we're going to file a Title 42 lawsuit on that clerk.
I love it.
Okay, now what's going to happen then? Because the law is very clear that they got to do it. Now what you think is going to happen to a clerk when they got 50 or 100 affidavits that state that they refuse to obey the law? She just lost her job. At the very minimum, may go to prison, and you're also going to lose damages to the person that they've damaged. Because that's also in the law too. I think it's $5,000 that they have to pay. So the bottom line is this, is if we get 50 or 100 people that are willing to do an affidavit and go to court and testify that this clerk did this, where are they going to go? They're going to shuffle that clerk real quick. And what's going to happen in the country?
Yeah, start talking.
They're going to get on the hotline. Hey man, did you hear Sarah Jane lost her job because she failed to file one of these sovereign documents? If you see these sovereign documents, you better be careful. And that's going to go across the country like a wildfire. And what's going to happen when 3 or 4 of them get in trouble and they lose their jobs? Because I'm going to tell you, always remember, and don't ever forget this, the big fish always eat the little fish. And so the guys up in the county that are hired in this clerk are going to say, well, that's all on that clerk now, she knew better. And we took care of the problem, and we're going to say, thank you very much. We're going to give them the option. Either you county commissioners can take the heat and go to prison with her, or you can cut her loose. So what do you think they're going to do?
They're cut her loose, but the sad part about it is they gave her the instructions.
Oh, absolutely, but that's okay. That's okay. We're still going to get the intended effect.
Yeah.
We know we can't fix it all.
Right.
We're not trying to. What we're trying to do is get the word to go around the country. Hey, there's been 7 clerks canned in the last 6 months for not filing these sovereign documents. What you think is going to start happening? They're going to start recording your documents, and they're not even going to say boo to you. They're going to say, thank you, sir, have a nice day.
And what my husband just reminded me is there is a thing when you have a job, your employer cannot require you to do anything that's illegal or immoral.
That's right.
So if they followed those instructions, then that's on that clerk.
Absolutely. And you got to understand, these, in many places, these are elected officials. They're bonded. They're all bonded. And that means that you can bring a civil case against that bond and get paid. Now, I'm telling you, when that bond gets suspended because of payment for wrongdoing, that clerk is finished forever. The federal law says they can never hold office again. Never is a long time. These clerks get paid good money.
They do.
They don't just get chump change, folks. They got a very prestigious job.
And they don't work.
Good benefits. Small counties get 6 figures.
The 2 of them in Russell County are both attorneys also.
Yeah, that's all right. Well, that's good. That's even better. They bonded more than one way. I always say that the more attorneys, the bigger party.
So, with recording, is there any complication if they're recorded both in de facto and...
No, there's no, it's not. Okay? They're not going to file them for you to start with.
Oh, they file one.
Well, they will, but go back down there in 2 or 3 months and try to do another one and see what happens. You'll be real surprised at the change in attitude, probably. Yeah, Tom filed a few in South Carolina. Now they tell when he comes through the door, they go like this now. And the guy told him, he called him in his office and said, listen, I cannot file your documents, I'll lose my job.
Sure will.
You don't file, you'll lose your job.
And that's what I told him. So we'll tell him you're going to go to prison and lose your job if you don't. But see, we got to start being smart, folks. We have not been organized. You're out here fighting a giant. How many of you know about the octopus? You don't know about the octopus? Some of you probably have seen this before, but I'm going to show you about the octopus. You need to understand how the octopus works. Okay. And don't y'all comment about my octopus because I'm not an artist. I don't know how many legs he's got, but anyway, there he is. That's not a sunbeam, that's an octopus. Okay. Okay. You know, that don't matter how many he's got. We don't care. He's got more than that.
We recognize him.
Okay. Now you got to understand the concept I'm trying to teach you. Okay. Now, when you're out here by yourself and you go try to attack this octopus, he's going to grab you with 3 or 4 legs and rip you apart. You don't have a dog's chance. Now, what are these tentacles? What are they represented from this octopus?
Agents.
Agents. Judges. No, we're talking about people here. Clerks. Law enforcement officers. IRS agents. That's part of the agents. And it just goes on and on. You got all of these protect the octopus. That's a U.S. corporation. Every one of them protect them. And the list is endless. They have all kind of people that do that. But what happens, you remember what I told you about respondeat superior in the law. Respondeat superior means that if Barney over here violates my rights, the president is responsible.
Right, okay.
Okay. So what we do is we let him know you're responsible. You remember the lawsuit we just filed last week? Did we let him know he was responsible for what these sheriffs are doing down here? Barney, we told him, Barney's got you in trouble. That's what we did. That's what we told him. And he understands. He's the master of the ship. And he is responsible for everybody on it. If they violate your rights, and we can prove they have, and we're going to prove they have, in a federal district court to the tune of $650 million lawsuit, and we're going to prove our case, that's not even going to be hard to do. Barney, all of a sudden, has put a bad mark against the president here. Well, guess what? It's an election year, folks. And I'm going to make a gentle suggestion to the president. You know, Mr. Obama, we don't have a beef with you. We got a beef with Barney down here. And if you're willing to take care of Barney, we're willing to help you. And you can stand on the news and brag about how good you were to the sovereign people. But what you think is going to happen to Barney down here? Barney's gone, bud. Barney's in trouble. Well, so you got a bunch of levels before you even get this far. You got the governor he's got to deal with too. Because the governor's not happy either because you got us in a lawsuit. Now we're going to have to spend millions and millions of dollars to defend this federal lawsuit because you did something against the law. I've been in these meetings before, guys. I used to be in law enforcement and I've heard them talk about it. You got us in trouble, and man, you're going to pay the price. I've been there. I'm telling you, I know how it works. And so what basically is going to happen is the president's going to get on the phone and they're going to go through the chain of command. He's going to call the Attorney General, and the Attorney General is going to call, Eric Holder's going to call the governor of Alabama. Bentley, I think is his name. He said, Mr. Bentley, we got a problem. Your sheriff down there has got us in a mess. He got us in a federal lawsuit for $650 million and we're going to lose. But these guys are willing to work with us if you'll take care of the problem. And the governor is going to call his secretary and prepare me a letter. Andy Hughes in Dothan, Alabama is going to get a letter in the mail and a phone call. And it's going to say, you are being terminated as sheriff and being replaced by my replacement because you violated the civil rights of the people. And blah, 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 a whole lot of legal stuff to go with it. But basically that's what happens. Okay, so what did we just do? We cut off one of the tentacles of the octopus. Okay, now if we go to court now and that judge over here, that here in this case decides just to bowl over all the evidence, then we're going to come after him and we're going to make him a black sheep to the octopus too. And now he's going to be hurting the master of the ship, and the master of the ship gets rid of people that hurt him, cause him problem, because he's the big fish. He don't have to put up with that. This guy down here is just a little fish. The same thing with agents, same with IRS, and same with all of these. Well, what happens when you cut off these tentacles?
Has no power.
He has no power. He can't feed himself, he dies.
That's right.
And that's how simple it is. Now, how do I know that works? Because I've been doing it for years. I've had at least a dozen law enforcement officials and people that worked in state departments and stuff like that dismissed from their jobs by using this same process. One of them was President Reagan's bodyguard. And he called me up, and I told him the day he fired me from my job, because I stood up for the truth. He fired me, and he called me in and he said, "You're fired." I said, "And?" He said, "Well, you got, I think he gave me 60 days to live," something like that. "You got to get all your stuff out off the state property and leave," and all this kind of stuff. I was a fire inspector, and I lived there. I was a fire chief too, so I had to live there at the property because that was my duty. And I told him, I said, and this is exactly what I told him. I said, "You'd rather slap Saddam Hussein in the face with a handful of sand spurs than tick me off." That's exactly what I told him. And he said, "We're the state. You can't do anything to the state. You're just an individual down here." I said, "No, you are not the state." I said, "You are down here at my level." I said, "And when this is over, you're going to understand that." So I put some heat on him. And basically what I did, I sent a nice little letter, special delivery, to the governor of the state. He didn't know that the governor and the state and my uncle were hunting buddies. He missed that part somewhere. That did help a little bit. I sent a letter, it's several pages long, to the governor of the state, special delivery, special courier by U.S. Postal Service, registered mail, directly to him, nobody else. Couldn't go to anybody else. Couldn't be intercepted. So they delivered it to his hand. Cost me some money to do it, but I got it done. That's Lawton Childs was governor. And Lawton, I introduced myself, of course, that I was his hunting buddy's nephew. That didn't hurt. And so I told him what they had done, and I documented it. I actually sent him documentation to show what they had done to me. And didn't hear anything from the governor. Never did. But one morning I was drinking coffee and I got this call. I said, "Mr. Turner." I said, "Yes." "Who is this?" He said, "This is David Farkas." That's the guy that fired me. He used to be superintendent of the prison where I worked. He said, "I need your help. One Christian brother to another." I said, "Really?" He said, "Yeah." He said, "Man," he said, "you've really put some heat on me. I'm going to lose my job." He said, "I really need your help." I said, "Mr. Farkas," I said, "if you did the right thing, you don't have nothing to worry about." I said, "But if you didn't, sin lies at your door and you need to repent." I said, "You have a nice life." And I hung up on him. And just a few months later, he lost his $106,000 a year job, his law enforcement certification, and he was working for Fort Myers Toyota for $25,000 a year. Lost his family, his wife left him, took his kids. And there's more to the story than that. And to show God does have a sense of humor. But anyway, this is the reason I know this stuff works. I gave the governor an opportunity. This was an election year, and I had a friend that worked as a reporter for the Tampa Tribune that hated Lawton Childs. The Tampa Tribune hated Lawton. And this was an election year, and so what I told him, I was going to go to the Tampa Tribune and print my story. And this was an election year, and they hated him already, so they'd take it and run with it, and he knew that. And it was a tough election because he was running against Bush. And that was a tough election, yes.
Tim, how do we tie this lawsuit into our individual cases? What will it do for us?
What you mean, tie what lawsuit into?
The one that you will file.
You can't tie your into my case. You can't do that. That's not the way it works. It's a specific case. I have a format that the judge helped me develop. He actually helped put the language in that we've already got that we'll share with you if you like. We'll put it on the website so you can...
We're all plaintiffs on there, right? You're the lead.
Yeah, well, you are, but we're talking... You can't, when you do a specific lawsuit, you don't want to start diluting it with other things. So this is a defamation of character and slander lawsuit. It doesn't apply to property. That's not, that would be going another direction. That wouldn't be a wise thing to do. They'd throw it out for merit if you did that. But what I'm telling you is for $350, I can show you how to do it yourself. Plus, of course, you got your mailings and mailings. And I'll show y'all, actually this afternoon when we get through with the class, I'm going to show y'all how we do actually we're going to stuff the envelopes for this lawsuit to send to the governors. I'll let you look at it and see how we do it. There's a lot of work goes into a federal lawsuit, especially at this size of a lawsuit.
I've been involved in a number of federal cases in my own situations, and I was looking at, and I had it all completed, I just never did it because of timing.
Yeah.
I was going to file a lawsuit in the federal district court against a judge, and I'm still possibly planning.
And you can.
But what they told me in the clerk's office is that I didn't have to notice anybody, that they would take care and they would notice all the defendants.
That's because all the defendants work for them.
Okay.
In your case. In my case, I'm required to notify. Okay. I have to notify all 50 governors because they're the agents. Okay. I don't have to notify anybody else. Now, I did notify the local sheriffs individually simply because they were the ones that were creating the threat, and we wanted to suppress the threat immediately. That was the strategy there, and it seemed to have worked. We're still walking around free. We haven't been bothered yet. So they were supposed to arrest us this week. I'm still here. I've been threatened before by bigger fish than him. I can guarantee you that. But anyway, when you understand that you can't concentrate on the big octopus, you got to concentrate on the person that you're dealing with. The clerk down there is bound by law to record your documents. The law enforcement officer is bound by law to uphold your constitutional rights, whether he likes it or not. He's bound by law to do it. If he doesn't do it, he violated you. Now we can make, if the deputy does it, the sheriff is responsible. And I can tell you, I've seen them cut them off in a heartbeat. Yeah, especially election time is a wonderful time to do this. They don't like any negative press. They don't like negative press around elections, and they'll cut, the big fish is going to win. The big fish will cut him loose. What they'll do is they'll take advantage of it. Sure. I've seen them do it. They will actually go out and cut that officer off publicly and say, we're standing for the rights of the people during an election campaign. And that old guy, he gets the boot. Well, what happens? Game and Fish Commission had a guy 17 years on the force, was absolute tyrant. Had this little fisherman, had a 6th grade education. He went out, him and his father, and they built a fishing net. Now, this family is many generations of fishermen. Went out and built a net. Well, if you've ever been around fishing community, you just string a net out in the backyard and they build it. Now, they don't go down and buy nets. As a rule, they build their own. Everybody's got their own little way they like to build their nets. It's fishing tradition. And so they went out and they built this gill net to catch fish with. They called the lieutenant of the Game and Fish Commission down to their house and inspected the net before they ever put it on their boat to make sure it was legal. They took it and put it on the boat and they used it for several months. It was inspected by several officers. One day, this guy, had 17-year veteran officer, stops them out on the water and says, your net is illegal. And he confiscated their net, their fish, their boat, their truck. He even took their truck. Oh. He took everything and confiscated it, impounded it in the lot in Tallahassee until they went to court and told them, and they charged them, and we're going to put them in prison for like 3 or 4 years for fishing with an illegal net that wasn't illegal. And he could prove it. So I helped him with the thing. Well, ultimately what happened is we gave the lieutenant who had personal knowledge of the net the opportunity to deal with this guy. He was his supervisor. Actually, the guy was a colonel, I'm sorry. The lieutenant came, but he worked for the colonel, and the colonel had personal knowledge that this guy had inspected that very same net. And so we gave him the colonel the option to either be brought into this lawsuit and charged himself for violating the civil rights of this man, or either he could deal with the problem. Well, guess what he did? The big fish ate the little fish. The colonel cut him loose. He said, man, but this was what was so funny about it, and this is something that you need to understand about these state agencies. They called this man into the office and they said, listen, you have violated the rights of this fisherman. He is suing us. And he has added us to the claim because of respondee superior. We're responsible for your foolishness. So you're fired. And not only are you fired, you got to go hire your own attorney now. We're not going to represent you. So he had to go, not only did he lose his job, he lost the revenue that it took to hire an attorney for $400 an hour to defend him in court. And so we just sent a nice little letter to the colonel to thank you, we're releasing you from the lawsuit. And that's how it works. You can learn to play the game real easy. The colonel had been there a long time. He'd probably been there over 20 years. And he wasn't going to sacrifice a career and income for his family and retirement for some yahoo out here that was violating the law. You're going to find the sheriffs are the same way. Now they'll tell them privately, yeah, you need to go harass their sovereigns, but when it comes public and it goes to court, that sheriff is going to deny even having anything. Oh no, I didn't ever do nothing like that. No way, I didn't do it. And they're going to run from it just as hard as they can. And they're going to leave the little fish to hold the bag. They do it every time. I've never seen it fail. And if you learn to do it right, you can make it happen too. Now what happens when you do this? Well, all of a sudden, you couldn't hire a game and fish officer to write a fisherman a ticket for about a year down there. They wouldn't even do it. They said, we don't know what's coming next. Because we explained to them, y'all are violating the rights. And that's how you got to deal with these issues. And land works the same way, guys. The judges, the lawyers, the banks, the clerks, all of these people are the tentacles that protect that corporation. You got to learn to take the tentacle off, make the big octopus responsible for their actions, and wherever it goes. If it's a lawyer, guess who's responsible? Every member in that law firm is responsible. Every one of the principals in that law firm are responsible for his actions. And I know it works. We were down at the courthouse in Houston County, in Dothan there, at the federal courthouse one day. We come in a little bit early before the trial, and there was a little meeting room sitting there on the side, and we heard these voices. We just were waiting in the hall there on our time to go into court. And I could hear there was some people chewing this guy out. And we didn't know who was in the room because the door was closed, but we could hear the conversation. And somebody was very angry. And they were telling this guy, said, you put us in this position, and you're the reason that we're here in this lawsuit, and blah, 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 blah. We got all this problem, and and they were just chewing this guy out. And it was funny. We were standing there, and when they come walking out, it was the guys that I had put the lien against. They were chewing this attorney up one side, down the other. And I don't think he probably didn't have a very good career after that. I've lost track of him. But I'm sure that he is not doing very well.
Tim, did you pursue, the guy lost his job, did you continue with the lawsuit against him?
I turned it over to the boy. He did continue with the suit. But what they did is they restored him and gave him his license back and apologized to him, and he got everything back. Now he didn't, as far as I know, he didn't get any cash settlement. He should have, but I was leaving the area at the time and I couldn't do it myself, so I turned him over to somebody else. But he did win the case. I don't think he got any money. I think he just got his stuff back.
Going back to the federal lawsuit, serving 50 governors. I know you and I talked personally about me serving my sheriff.
Yeah.
Is that going to be required in order for our sheriffs to get notice?
No, the governor is responsible to notice everybody in the state.
Okay.
All I got to do is get it to the governor. Okay, so everybody understands the respondee superior and the reliability. You need to understand that clearly, because when you're dealing with these little guys down there, they act like they got all the power in the world. They don't have very much. When you go to deal with an obstinate clerk, just be nice. Take your witnesses. Don't get into an argument with these people. Look at them and smile, because all they're doing is setting themselves up for a fall. If you do it like I tell you, you just go down there, you be very nice, be very polite, don't ever get cross with one of them, because they don't really know. Most of them are doing what they're told. They really don't know. And it's not our intent to cause harm to the clerk. It's our intent to get results. And so what we can do, you don't have to sue the clerk and you don't have to hurt the clerk. What you can do is you can get them to the brink where you can destroy them and then let them off the hook. And I'll guarantee you, if you do that, that every time you go in that courthouse from then on, you're not going to have any problems. Because isn't that what we're really after? We're not trying to hurt people. What we're trying to do is educate people and make them comply with the law. That's all we want. We don't want anything extra. I did that to a postmaster. Had a postmaster took a registered mail sticker off of my documents that were going to the United States Treasury and put a certified mail sticker on it without my consent. I sent the document, or they sent the document. I was actually doing it for somebody else. It wasn't my document, it was a friend's document. And the friend, when he found about it, he went, we couldn't find the registered mail receipt where it was delivered. But we found a certified mail. And so we found out through one of the postal clerks that the postmaster herself had taken the thing off of it. Oh, he immediately went ballistic and said, I'm going to sue them, I'm going to do all this, I'm going to get their job and all this kind of stuff. So he went down and talked to the postal inspector over here in Ozark and told him and said what had happened. And the postal inspector told him, he said, if we prove that happened, she lost her job. He said, well, I got the receipt right here. It shows where I paid for the registered mail receipt, and she put a certified on it instead. She took the receipt off and put a certified on it. We can prove it. We had evidence. He said, she won't survive this one. So they don't play with registered mail. He said, she'll lose her job for this. And so I was with the boy and I said, listen, let's talk about this for a minute. I said, do you want to destroy that woman's career? She made a mistake. She probably did it intentionally. I said, but why don't we go talk to her? I want to get her job. He was one of these he was one of these patriots. He wanted to get her job. If I calmed him down and I said, listen, let's go talk to her lady. So we went and talked to the postmaster. I said, can we talk to you for a minute? And explained it to her. And she knew she had been caught. She knew she was in a bad spot. I said, we don't want to cause you harm. I said, but y'all have been really giving us a hard time. You don't want to give us registered mail receipts. You give us harassment. I said, we just want it to stop. And she said, if you'll drop this, you won't never have any more problems in this post office. And now when we walk in, she smiles and says, how y'all doing? And have a nice day every day. She's still postmaster.
Sign your clerk.
Yeah, you just gained a friend instead of made an enemy. And that's all we're trying to do, folks. But we educated a postmaster on, you just can't, we know better. And this is the things you got to understand. This is what we got to do with these clerks and these other people. And I think that we probably need to take a break. People are getting up. Let's take 10 minutes. John, you doing okay, buddy? Oh, Mike?
Got it.
Thank you.
We almost had hand delivered to you.
I appreciate that, and I will take care of it.
Did you happen to talk to Brother Graham this morning?
No, I hadn't.
Did he tell you what happened?